Sprague and Assistant District Attorney Shanan Buckingham.
All right. Good afternoon, Counsel. Good afternoon, Ms. Clancy. Counsel, can I see you in sidebar? All right, Counsel. What thought we'd do is kind of just go through kind of a list of matters that we have to. So I know we're going to talk about panelment, talk about scheduling, and then some of the pretrial matters. We're going to go. I want to talk to counsel in regards to if the defendant at some point is going to request be absent from the courtroom at some point during the trial. I want to go over.
That's not carved in stone.
No, I know I'm just the reason I wanted to raise it so that if it, and it's not carved in stone, but if it comes
I
up,
can tell you, Your Honor, that without invading attorney-client privilege, she does not intend to
Right.
seek to absent herself at all from this trial. She'll be here from beginning to end.
and that's fine. The only reason I'm saying it is I know that was raised. It may come up. That's all. And if it comes up, it may come up because of observations I make. I'm not saying that the defendant would be requesting that, but I just kind of wanted to let counsel know how I would handle that if that came up. Then we want to talk just about, and then we've got the blood spatter motion we have to address, I believe.
Your Honor, I've changed course on that, and I've talked to defense counsel about that today. I'm no longer going to, my goal is no longer to use a physical demonstration.
Okay.
During prep with the witness, we realized that a series of photographs might better display the different types of spatter. So the witness is sending me photos that she uses during trainings when she trains other people, and I'll send those to defense counsel, and we should be able to agree on some photos, I think.
All right.
That should be fine.
And so with that, we don't need to address that motion today.
I don't believe so.
It can be difficult if you have
I
photos.
consulted with Peter Valentin, my expert, and I told him that it's my feeling and understanding that we would not be doing the dope ad today, so I'm good on that.
Okay, all right. So we won't address that. So just why don't we talk a little bit about panelment and the procedure that I would consider doing is implementing a questionnaire. And I drew up a draft of one. I'll give it and can kind of do a final talk through on Monday. We do that, but this is just so you can take a look at it. It's just 8 or 9 questions. So my thought would be have the jury come up here as a whole, give them an introduction to the case, give the Commonwealth. Do we have a statement of the case?
Yes.
I submitted the final pretrial memo. I believe defense counsel submitted a paragraph that he would like read that the Commonwealth's objecting to.
All right. Well, why don't we circle back on that and then go through the general questions with the jury, then send them back downstairs to fill out this questionnaire. My other thought is that there is an extensive witness list. And it may make more sense to have the jury be handed a copy of that list. Bring that down with them when they're answering the questionnaire. Because last I counted, it was over 200 names. And I think it would be difficult for anybody to sit there and try to remember who it is. Do I know that person or not? So my thought would be to give them the questionnaire, give them the witness list, send them downstairs to fill that out. That then gives us an opportunity to take a break, line up for the individual part of the voir dire, and then bring them up and bring them in one at a time into the courtroom over here at sidebar and just proceed that way.
I think that's a good idea, Your Honor. I would just ask that those witness lists be collected from the jurors as they leave.
It's a good idea. Yeah. I have Mr. Reddington?
Yeah, that's fine.
All right. So that's the way we'll do that. Let me see. Here's a draft of those questions on the, we can go over these on Monday, but this is being proposed. Don, could you? Thank you. So,
Your Honor, the witness list, would that be a combined list with both?
right, and they won't be listed as defense or Commonwealth witnesses.
Thank you.
So this is just a rough draft of the questions, and then bring them up. My thought would be to impanel 18 on this case, because it's going to be a lengthy trial. And then so everybody's going to get, well, I know there's a motion for additional challenges. So why don't I hear you on that at this point? Mr. Reddington?
You're going to talk about the questionnaire eventually, or?
Yeah, I'll give you, right, I just,
Okay. Your Honor, I have filed a request for additional challenges. I understand that would be entitled to 18, is that correct?
Correct.
As I was told, you might
Yeah.
contemplate 18 jurors.
yeah, we're going to see 18.
So I'm asking, and I don't know if the government agrees, that we would have additional jurors. Obviously, that would be committed to your sound discretion, but it's the type of case, not only publicity-wise that we usually deal with, but just the sheer emotional impact that this case is going to have on jurors. And I have always felt that jurors really, take to heart their obligations under a jury trial. And I literally had occasions where I run into jurors, some older cases, emotionally charged cases, in public places, and they would shake my hand and they cry. And that to be like 5 or 10 years later. And the impact of this case, which in my decades of trying cases is probably the most emotionally disturbing and challenging, I think is going to have a significant impact on jurors, more so than the usual that we deal with. So recognizing that 18 challenges might sound like a lot, I just feel that perhaps an additional number of jurors subject to your discretion would be appropriate, especially with the length of time that they're talking about, along with the emotional factors.
Come on.
I would join in the request for the additional peremptory challenges. And I just have a question in terms of if the court is going to impanel 18 about the seating of the 2 additional, because we want to make sure they have adequate viewing of the monitor and the witness box. But other than that, I have no objection.
All right, I want to consider this motion. With both parties requesting it, puts it in a little different path that you usually have on this. So, but I do understand the uniqueness of this case, the allegations. So I'm going to take that under advisement. We'll let the parties know in the next day or two. So that'll be under advisement. And in regards to the seating of the jury, my thought would be, as I've done before, is to have not to have those 2 side by side, but one in front of the other. And I think we haven't had that problem before in regards to being able to see either the witness, because it kind of lines up, and then the screen, which I imagine is going to be used here. Might have to turn it a little bit, but the cases I've done before with the 18, all the jurors were able to see. And then what we'll do is I'll just ask them as we're going through this, because everybody can see this. If you can't see it, let us know. If we have to adjust the screen or adjust the seating at that point, we'll do that. But I haven't had that problem, but I don't have them side by side like that. So, all right. Any other questions in regards to the empanelment, Commonwealth?
No, Your Honor.
Mr. Reddington?
I don't think so.
I think we've all done cases with each other. So I would expect they'll be kind of handled the way we've done it before. So that would be the empanelment. As I said, with the schedule, as I indicated over here, I'm going to tell the jurors what the schedule is going to be, but let them know that it's a fluid situation in regards to how long the trial is going to be, how long the schedule's, on a day by day. So I'm not going to be very precise, I don't think. And we'll talk a little bit more maybe on Monday in regards to how I address that with the voir dire. Let me see. The other issue that I had, just in regards to, and I know Mr. Reddington indicated that you don't believe there's going to be a request for the defendant to be absent from any of there. And so what I would, just so the parties would know, if that comes up under Rule 45, what we'd do is we'd just do a colloquy, maybe do a signed waiver, and we could deal with it that way. So it wouldn't take up a lot of time. I think it's just better for everybody to know that's the procedure that I would follow, kind of after looking at the case law on that. In regards to the view, I know that I had allowed the Commonwealth's motion for review. There was a proposed order with the Commonwealth's motion. I don't think I got a proposed order from the homeowner. And I think he was invited to propose one, but I haven't seen anything. So Commonwealth, what's your position in regards to, it's your order, but what are your thoughts in regards to that?
Well, I was approaching it as most of these types of cases that I do. We usually let the homeowner know when we'll be there. They make sure they're out of the home when it's unlocked. We go in. A case like this where we have 18 jurors, maybe send them in groups of 4 or something along those lines to see whatever myself and defense counsel want them to take note of, and then leave the premises with an instruction to the jurors they're not to open any closets or anything like that or touch any personal items. And I think that's pretty much what's encompassed in the order, if I recall.
Yeah. Mr. Reddington?
I have no position on that, Your Honor. Your Honor knows that I indicated I don't think it's necessary to have the view plus videos plus photographs, but I understand you've already made your decision on that. So it's a house that is now occupied by a man and his partner. It does not look at all like it did before when Lindsay and her family was living there. So I defer to your discretion on any specifics on the view.
All right. So my intention would be to, as I said, allow the motion for the view, issue that order in line with the proposed order that was given by the Commonwealth, and then as we go forward, we can give the homeowner a notice on that. We'll have police and security there to address any of those concerns. In the order regards to the media, we'll also deal with the no photographing of the jury during the view.
Could I just make an observation, Your Honor?
Sure.
It's a situation where obviously we're dealing with people that are civilians or professionals. This is not a situation where we're looking at a drive-by murder in the middle of an inner city where there's danger to jurors and stuff. Can I ask that the court at least limit the police presence? I mean, I have had it with police officers on motorcycles buzzing back and forth next to the jury bus, and police officers stopping traffic and blue lights behind you, blue lights in front of you. There's no need for that type of a police presence in this case. We're going to take a bus to a house in a residential area in Duxbury, and that's it. I understand that there may be a need to, close down a road or something, but I would ask that we don't have such an overwhelming police presence for obvious reasons.
Come on.
We could go to sidebar. We do have a plan in place, but for security purposes.
Sure, yeah. Sidebar. One of the, motions that was filed and argued had to do with photographs. I know, and I allowed the Commonwealth to be able to introduce some photographs. Just so, again, there's no surprises. If the Commonwealth can provide me a copy of the photographs that they intend to introduce, so I can look at them and make sure no surprise, but would be in line with the ruling that we talked about.
Are you referring to the autopsy photos, Your Honor?
Whatever photos or the crime scene photos, perhaps.
We could provide you with either the disc with all the photos or it's the issue. The reason I'm hesitating is at the moment as we're prepping, we're deciding what photos to use, but that could change mid-trial. So I could give the disc with all of the photos for you to review and be prepared in case there's an argument about one of them.
I don't think there's going to be. We've already kind of had the argument in regards to photographs, and I also allowed that some photographs will be admitted with limiting instructions. But I just kind of want to make sure that I understand really what the jury is going to look at, so I can make that final determination. So kind of however you want to do it. If you want to give me all the photographs, that's fine, or just some representative ones. I'm not going to hold you to if there's one that's a little different angle from some other one, but just so I have some idea kind of what we're going to have to deal with.
And I can bring in copies of the autopsy photos as well.
Okay, that's fine. All right, thank you. The other thing we had talked about last time was that the 3D model was, I'm not sure if that was done or if that's an issue now or.
It's almost complete. I'm expecting to, Shanan Rucci from our office has been working on that. And as soon as it's done, provide a copy to defense counsel in the court to look at. But it's going to be a digital monitor that's on the screen.
So it's a digital representation of the house?
Yes, digital model of the home. It'll have an exterior view, and then it'll have each floor of the home. And it's just a digital model, nothing physical.
All right. So if you could just make sure Mr. Reddington sees that copy, sees that, and then we can deal with that as we come
I'm sure they will,
close
and
to it.
I have no problem with the AutoCAD stuff. I may have one myself. So it's
Okay. All right. So we won't worry about that. The blood spatter motion, we're going to take that up later. What other issues do we have? I know that there's one in regards to some additional witnesses, but besides that, any other issues we need to take up?
The Commonwealth sent defense counsel several proposed stipulations. It would be helpful to resolve those.
I haven't had a chance to look at them yet, but I'm sure that I'm more than likely going to agree with all their stipulations, because if it's to avoid having people, in a ministerial sense, like somebody looked through a scanning microscope and they handed a slide to somebody else that put it in an envelope and somebody else looked at it. I have no problem with that. I'm not, as you well know, we've indicated that the mechanics, if you will, of the homicides and the actual event itself, we're not contesting. This is why you've already heard me complain about the autopsy photographs and all the gruesome stuff we're going to have to live through. But it's to their stipulations, I'm more than willing to stipulate to avoid having all these witnesses.
And just so the court's aware, they are witnesses, as defense has described, mostly laboratory witnesses. It would save calling 31 people.
Yeah.
So.
All right, and that's kind of what I figured was coming. So that's I'll anticipate that there's going to be a fair amount of stipulations that'll be done. I'm not going to hold anybody to it at this point till we get the specific language in it.
My only concern is that in light of Commonwealth versus Gordon, I think there needs to be a colloquy with the defendant about the stipulation. And I haven't done one myself, so I don't have a model for the court. I'm not sure if other judges have done it at this point, but that's something, I think it would be something along the lines of other similar waivers of a constitutional right, but.
When someone stipulates to an element.
Right.
Yeah, so I'll either borrow one or draw one up. So I think that's a good idea. All right, I know that there was still a couple of remaining discovery motions that were kind of floating around. Do we need to address any of those? Mr. Reddington?
Are you referring to the defendant's motion for relevant discovery?
Yes.
Okay. For the record, I would note, run at paragraph 1, I'm looking for automatic mandatory discovery. I believe the government has been very effective in providing me with discovery. I mean, when there's a witness that's interviewed, they send me a copy of the interview. If there are notes, they send me copies of the notes, so I don't have any problem with that. I don't believe that there are any unusual issues that have been flagged on this motion, and I would ask if the court would entertain allowing paragraph 3, which is potentially exculpatory evidence, only because I know the case law. Not that I doubt that they would provide me with exculpatory evidence, but I believe I have to have a motion allowed for the record to have it in play as far as the government's obligation that they recognize, and I respect the fact that they do and expect that they would. But nevertheless, I would ask that you allow motion for exculpatory evidence, as well as motion for statements of the defendant. And again, I don't anticipate that there are extensive statements of Ms. Clancy to law enforcement. I don't believe there are literally any. And I'm well aware I have the discs of the government's doctors interviewing her, so I've already got that, but I would ask you to allow that motion as well.
Commonwealth?
So if I'm understanding correctly from this motion, defense is just asking for the allowance of paragraph 3 and then any statements of the defendant. Is that correct?
That's correct. Yep.
So I have no objection to statements of the defendant. We've provided those, and if any come to light, we will of course turn those over, but I don't expect any. In terms of paragraph 3, my concern with paragraph 3 is the last paragraph. The last couple of sentences where it says the new Rule 14 also requires the Commonwealth to inquire of each witness, officer, and agent and agency as to whether they know of or possess any exculpatory evidence. And then that last sentence, the defendant requests this court order the Commonwealth to produce each and every inquiry and each and every response.
I would narrow that, if I could interrupt you, I apologize. I would narrow that to, in the event that there are statements that disclose exculpatory evidence, the government would then advise the defense. They don't have to notify me of every single person they've talked to.
Well, so I made a note of that. I was wondering the definition. I'm going to make a suggestion. Maybe if the three of you kind of come to an agreement as to that language, and then I'd allow that as to make the endorsement that reflects the actual agreement instead of just kind of a blanket one that the parties may later disagree with what was meant. So I'll allow that pending the proposed language. All right.
So that would just be paragraph 3.
Paragraph 3, and also regarding the statements of the defendant.
Which I don't think is its own paragraph in here, is that correct?
I'm sorry? What?
Statements of the defendant, is that a paragraph?
It would be, yeah, just it's statements of the defendant in general, yes.
In general, okay.
Okay. All right.
And no further action on the rest
Right.
as of now.
All right.
Right, this is a discovery motion filed as well, where it's a request for a 17B2. Looking for state police troopers, local police detail to sit at defendant's hospital room. Government has provided me with today a large number of duty assignments and records and documents. I believe they're going to provide me with the state police, but I would say that motion can be tabled. They're not
Right.
comply with that.
So I'll take no action on that. I think that's pleading number 113 for motion discovery under 17B2.
Correct.
All right. So there'll be no action taken on that.
Okay.
All right. And then I think the only other kind of issue that we need to take up is the defendant's motion that was filed.
No, there are a couple more.
Oh, there are. Sorry.
Yeah, very briefly, Ren, as counsel had already indicated, on the document titled Joint Pretrial Memorandum,
Oh, yeah. Okay.
the government sent an agreed statement of facts to be read to the jury, basically alleging on January 24th, 23, the defendant strangled her 3 children, naming them and their ages, with exercise bands in the basement of their home, thereby murdering them with deliberate premeditation and extreme atrocity and cruelty. And that's the extent of what would be referred to as the agreed statement of facts by the government. I then submitted a request that Your Honor would consider adding paragraph that Lindsay Clancy denies the allegations that she is guilty of, quote, murdering them with deliberate premeditation and with extreme atrocity and cruelty, end quote, and notes that she has accepted responsibility for the acts resulting in the death of her children, however, was lacking criminal responsibility at the time of the acts as a result of postpartum depression, psychosis, and involuntary intoxication. As a result of ingestion of numerous prescribed medications, Lindsay Clancy is thereby alleging she is not guilty due to a lack of criminal responsibility and will present what is referred to as the insanity defense, which I know is one of the questions that you would put in the questionnaire.
Commonwealth?
So, Your Honor,
Mr. Reddington, do I have a copy? Is that submitted?
I mean, we send them
provided a copy of the joint pretrial memo to
I have the joint pretrial, but I'm just,
The statement of facts is at the beginning, the proposed statement of facts for the Commonwealth.
I was looking for Mr. Reddington's version.
Because I know I sent them to them.
All right. All right. Yeah, go ahead, Ms. Sprague. I'm sorry.
So the Commonwealth would object to the paragraph as a whole. We would not object to the statement, Lindsay Clancy denies the allegations and that she is alleging she's not guilty due to a lack of criminal responsibility. But the rest would have to come in either through her testifying or other witnesses testifying, saying that she denies the allegations that she's guilty of murdering them with deliberate premeditation and extreme atrocity and cruelty kind of flies in the face of the statements earlier that what happened is not in dispute. So that is the reason for having the evidence about what happened to Cora, Dawson, and Callan, and including the autopsy photos, because that all goes to extreme atrocity and cruelty and deliberate premeditation. And then the rest where it notes that she's accepted responsibility, again, that would be putting evidence before the jury or statements before the jury that may or may not ever be in evidence. So I think the standard, she denies the allegations, and then including what the defense is, which I usually object to, but I'm not in this case because it's public knowledge. So those two statements I think would be sufficient, and I don't think the rest would be appropriate.
What I've done in past cases like this, I think the one we did a couple of years ago, was basically in the statement of the case after with the Commonwealth's allegations to say something about the question before you will be whether or not Ms. Clancy was criminally responsible if she lacked criminal responsibility. The prosecution has the burden of proof. The prosecution must prove beyond a reasonable doubt that she was criminally responsible at the time that she killed her 3 children. Any objection to that?
I do object to giving an instruction such as that, in that the case law states that we're not required to prove that she had criminal responsibility until the defense raises it. So at that point at the beginning of the case, it hasn't been raised. I'm not objecting to it that that's her defense, that she lacked criminal responsibility, but I object to an instruction at the beginning when that evidence hasn't come in. I expect it to come in, but things change during trial. You never know. It's the same as with self-defense instructions. I object to those at the beginning of the case because it's dependent on evidence that comes in during the trial.
Then what's the basis then for asking the jury in the impanelment questions about their position regarding the defense of criminal responsibility?
Because like self-defense, we expect that will be an issue. So we want to know if it's going to affect our ability to be fair and impartial. But I don't think the instruction comes until it actually becomes an issue. And I understand it's the court's discretion on that issue.
Yeah, I'll take a look at them, but just so everybody, I'm probably going to give something similar to what I gave, what I just kind of read out, just to kind of tell them this is the issue. You know, this is the defendant's position that she was not criminally responsible. This is the Commonwealth's position, is that she committed a crime. And so it'll be something along that line. And I'll show everybody before we read it to the jury, so everybody can kind of have some additional feedback. But it'll be something similar to that, I bet. All right. What else? Any other issues before we get to the?
We did file a request for the court to consider, I don't know if you have it, the motion of sequestration of the jury. You didn't have that?
No.
Okay.
You see this, Commonwealth?
I have, Your Honor.
Like I said, I know that when we file them, we send them to the VA, we send them to the court, so.
No, I have to follow my sword. It was sent to me. I had seen this one.
So the motion's left.
No, but I'd like to, just so I don't blame somebody else. It was sitting on my desk. All right, well, Sprague, I'll hear you on this.
Your Honor, I basically can be very brief. This is, as I indicated, a very unusual case emotionally, factually. Government's estimating 6 to 8 weeks for a trial, maybe less with the stipulation. Nevertheless, it would be a huge imposition on jurors. There has been extensive pretrial publicity, as you know, from the motion for a change of venue, which Your Honor heard and denied, which would be renewed at the time of the impanelment, depending on the way the jurors react to the questions in the sidebar individual voir dire. So my concern is that with all of those issues, and I understand that it's unusual nowadays, we don't really do sequestration of jurors. I think this is a very unusual case that may warrant that. And even if it's a possibility during the course of the trial, I think that the court should at least flag that issue for the potential jurors, for them to factor that into their own determination of their availability. So that's why I filed the motion.
Como?
Your Honor, Commonwealth objects to the motion. I think that the court will instruct, well, I know that the court will instruct the jurors not to go on social media, not to read about the case, not to pay attention to any of that. In addition, the court typically asks the questions every morning. If they've been able to follow those instructions, they're presumed to follow those instructions. So I don't think sequestration is necessary, and I don't think it would be necessary to ask them about something that may never happen in the case at impanelment.
I'm going to deny this. I will, said I'm going to ask the jury if they've heard of anything before, if it's affected their ability to be fair and impartial. I'm going to ask them every day whether or not they've seen anything, and also go instruct them not to view any articles or social media in regards to this during the course of that. And I'll follow up every day to make sure they follow those instructions. So I'm going to deny this motion.
Do I have to note an objection every time you deny a motion?
No, I think my denying it is to save that.
I think there's one more motion.
All right, what's the last motion?
Last motion, Your Honor, before we get into the jury questionnaire, I think would be caption defendant's motion for jury instruction. Your Honor, when you give the instructions to the jury on the law after we've picked the jury, and I believe you do it before openings, in light of the fact that it's obvious that lack of criminal responsibility is the defense, is the central bedrock of the defense in the case, I would ask that the court would, in addition to instructing the jury, as you do in a generic sense, about proof beyond a reasonable doubt, that the court would also instruct the jury that as it relates to the burden of proof, in the unusual situation where you're dealing with lack of criminal responsibility, that it is not the defendant's burden to prove that she is lacking criminal responsibility, but in fact, upon presentation of evidence, it's the government's burden to prove beyond a reasonable doubt that she was not acting as a result of a mental disease or defect. So I'm just asking that you would add that to the generic instructions.
Como?
Your Honor, similarly to the argument that the Commonwealth was objecting to the criminal responsibility being mentioned in the statement of facts, we would also object to the preliminary instruction, full instruction about criminal responsibility, because as my sister said, it is the defendant still has to raise it. And they have to raise it not just by saying it in an opening statement, they have to raise it by expert testimony, lay witness testimony, or the actual facts of the case. And so that isn't done until the case is underway, and preliminary instruction it comes well before that. So that is relying on Commonwealth versus Santiago, 485 Mass 416, a 2020 case that reiterates the instruction isn't necessarily need to be given in a preliminary, or in that case, it was actually for jury instruction at the conclusion of the case if the evidence wasn't raised. But I would suggest that the idea is even stronger, that if we haven't even presented the jury with anything, then they shouldn't be preliminarily instructed on it. If Your Honor was inclined to give it because it is a discretionary thing, I would ask that you stick to the language of the model and not how counsel phrased it, because as you're familiar, the actual instruction when it comes to what the Commonwealth must prove with a criminal responsibility issue is not just whether we can say that they don't have a mental disease or defect, because the evidence may show that, but that is not the requirement for the jury. If there is a mental disease or defect, then the Commonwealth has to prove the other two prongs of the criminal responsibility statute. So the way it's phrased in the motion, I'd ask you not adopt that language and that you stick to the model if you are inclined to offer it, but we would object to the giving of it.
What if I instructed the jury in a sense, almost like hypothetically, that it's anticipated that the defense of criminal responsibility is going to be raised? If that's raised, this is what the law is.
Well, I would suggest that we don't want to be caught in a burden shifting situation on a preliminary instruction. So maybe that language is a little bit too close. I think it's either Your Honor gives it as it is in the model in the preliminary as a preliminary instruction, or it's not to be given and just to be addressed at the conclusion of the case.
I generally give it. I understand the Commonwealth's position, but I generally think it's a good, well, I'll just leave it at that. I generally will give that. So I'll take a look at, but I generally give the model language that's suggested. So, all right. So, all right. And then there's one last motion that was filed yesterday. Did the Commonwealth have an opportunity to review that?
I briefly looked it over. I would suggest that we shouldn't even broach this motion in that it violates Rule 14 discovery, and that these individuals have been identified by initials only with no other information, no statements of the witnesses, no indication of what these witnesses have to offer or the background. And it's 1 week prior to trial. So I'd ask that it just be denied on its face.
Well, I understand that, but it's been raised. So I'm going to hear from the Commonwealth, and I'll hear from the defendant first, then from the Commonwealth. I'm sorry, and then I may have to take it under advisement myself, and it may be the argument that there's just not enough here for me to make a decision is there. But I think I want to give the defendant the opportunity to argue this. So, Mr. Reddington, this is the motion to eliminate to permit testimony from witnesses who have themselves been, according to the motion, victimized by the medical system regarding the issues of postpartum depression and postpartum psychosis.
Yes, Your Honor, thank you. Your Honor, as I say in the affidavit, and as you can well imagine, I have been contacted by many people who have, in a very moving, emotional fashion, advised me of these horrific issues that they've been dealing with postpartum depression, postpartum psychosis, hearing the auditory commands, having intrusive thoughts to hurt or kill their partner or their children, infanticide, as a result of postpartum psychosis, medication issues, contributing to the postpartum depression, postpartum psychosis. And it's so easy for us as a society to say in a troubling case like this, oh my God, she's guilty, throw away the key, put her in jail and just be done with it, because it makes everybody feel better. It's a feel-good reaction that, okay, somebody has been punished. because of doing a very bad thing. But as we know, when you're dealing with the issues of lack of criminal responsibility, I don't like the term insanity, but nevertheless, when you're dealing with somebody who is suffering from a medical a defect or a disease, and they have actually experienced something that is so outside the ken, if you will, of jurors, of normal people, for us to believe that somebody's hearing voices, the initial reaction from any one of us, I think, in this courtroom would be, come on, you're not hearing voices. What are you talking about? You're making this up. You're trying to avoid responsibility. But it is true, and it happens, and it is an affliction that people have put up with. And if they are permitted to testify as their experience themselves as to postpartum depression, psychosis, the concerns and the fear that a woman has, and I say as a woman has, because guys don't know about this. You know, we're so quick to go out, and we're mighty and strong, we have many beers, and we're real quick to say, throw away the key on it. But a woman who has suffered and has put up with this affliction should be able to testify and say, probably in an emotionally charged fashion, very credibly, I too have heard these command voices. I too acted on the command voices. I too have had insomnia. I too have had hedonism where I don't even care if I live or die. I have no emotion. I can't feel. I can't laugh. I can't love. I can't hate. And I think that that is important. Now, before I disclose the identity of these people, it seems to me that what I have to do is present the general legal issue to you as a preliminary gatekeeper almost, where you would say, hypothetically, I think upon sufficiency of proof, it is admissible. And I am inclined, you the judge, to allow that evidence before a jury, at which point I would then, of course, disclose the identity of the people with their knowledge and consent, their medical backgrounds, and the government could then send their cops out to interrogate them or intimidate them or talk to them or do whatever they want to do. But if they get on that witness stand, they have credible evidence to give. So it's a two-part. I can't really give their names and addresses without knowing. You may say, as a matter of law, it's not admissible. Somebody's individual experience with a narcotic, with a drug, with a disease or a defect is not admissible in a sense of the specifics of a trial. And if that's the case, then it shuts down the issue and that's the end of it. But I had to raise the issue preliminarily.
Thank you, Your Honor. I'll incorporate what I said before about Rule 14 and the lack of notice in the 1 week prior to trial, but also defense counsel cites no rule of evidence that would allow for the admission of layperson testimony about these issues. He cites to the battered woman statute, but in that statute itself, it refers to expert testimony, not laypersons saying, I had this experience, so the defendant must have as well. And then I think what we come to is it becomes more prejudicial than probative in that say you allow 16 people to come in and testify to that, then the Commonwealth gets to rebut that with their own witnesses, women who suffered from postpartum depression and psychosis, who did not kill their children, who locked themselves in a room to keep themselves from harming their children, who got in a car and drove away so they didn't harm their children. And so then it becomes a trial within a trial. And it's more prejudicial than probative. There's no rule allowing the admission. And it would delay the trial, in all honesty, because then we would be filing a motion for discovery on these witnesses, their medical records, having them interviewed by police, which would take time. So I would object to this motion.
I'd like to know who these people are that were locking themselves in rooms and getting in their cars to avoid killing or hurting their children.
Just go on Facebook. They're all over.
But isn't that the whole problem? I think what the Commonwealth is saying, that this isn't just a trial within a trial. It would be 16 trials within this trial. I understand the argument, especially the kind of comparison to the battered women syndrome. But as those cases develop, I'm sure Mr. Reddington may remember, as those cases that became more and more admissible, it really hinged a lot upon the testimony of experts. And in this case, I anticipate there's going to be experts that are going to talk about the reality of this postpartum depression and postpartum psychosis. So that's coming out. And these are testimony that'll come from the experts, I think, on both sides. It doesn't seem like there's a question of whether or not postpartum depression or psychosis is real. I mean, all the experts seem to agree that it's real. So because of the ability to get the probative part of what those women would bring to the court, the experts can give that. So I'm going to deny the motion at this time. All right. Anything else we need to address, Commonwealth?
I just think on the questionnaire, I was looking over the questions. I don't have any objections. I only request an addition. On number 2, it asks about a family member or close friend being diagnosed with postpartum depression, or generalized anxiety disorder. It also asks to include bipolar disorder, as most of the experts in this case have diagnosed the defendant with bipolar disorder. So I think it'd be important to have that information.
All right. Anything else in regards?
And also, Your Honor, there's no question on here regarding medications, whether people have any experience with psychiatric medications and whether that would affect their ability to be fair and impartial, either experience or views about. Is that the case?
Mr. Reddington?
First of all, if I could just harken back to the orders that you've given on the motions to eliminate, and I don't mean to seem paranoid, but you, I'm sure, understand the appellate courts in Massachusetts have repeatedly stated that on a motion to eliminate, if the defense counsel does not object, you're waiving it. So I just want to make sure, number 1, for the appeals court, if necessary, or the SJC, I object. And is it my understanding that any further objections, I don't have to keep objecting because I respect your ruling that I don't have to?
Come on. I have no problems with that. I think especially it's clear that the issues were raised on the motion to eliminate. I've ruled on them. And I think it doesn't need to be a recurring objection on those.
I would agree, for the record, Your Honor, that if whichever party was affected by the denial, the objection is there.
Okay. All right.
All right, addressing the questionnaire, Your Honor, if I may, it's an interesting issue that we're dealing with. The questions that have been requested, have you, a family member or close friend, ever been diagnosed with postpartum depression, or generalized anxiety disorder? The next question is, skipping over the NGA, number 4, have you, a family member or close friend, ever been diagnosed and or treated for mental illness or condition? And then going down to number 6, have you, a family member or close friend, had an experience with a psychiatrist, psychologist, or mental health facility that would make it difficult for you to be fair and impartial in this case? And finally, number 9, do you believe that a person's mental illness should not be considered when determining their guilt or innocence? So, going backwards, number 9, this is very similar to when we ask jurors or we tell jurors, do you understand that a defendant does not have to testify in this trial? Do you understand a defendant does not have the burden of presenting evidence on his or her own behalf? And many times at sidebar, jurors will say, well, I think they should tell their side of the story. And then the judges will say, well, if you are instructed by me that that is not to be considered, can you then abide by my instruction and be fair and impartial? And they always invariably say, well, yeah, I could, I guess. And then they will be accepted. I'm concerned about raising all of these so personal issues. There is a stigma in this country of mental disease or illness. There is, whether we acknowledge it or not. And it's embarrassing to many people. And I'm just concerned that jurors would, let's say they answer yes to question 2, that you or a family member has been diagnosed with PPD or depression or generalized anxiety disorder, and they say yes, then that's going to open up the inquiry into when, where, how, who, what medication, and will then invariably lead to kind of an inverse challenge by repeated challenges by the government, I think, to pretty much any citizen who comes in here. It's almost like a reverse Batson challenge. Any citizen that comes in here and has had mental treatment or has had what they perceive to be a mental disease, and they have been on medication, they're going to say hypothetically, yes, I have. And I saw Dr. So-and-so, and I think that the shrinks are useless, and I think they're terrible, and I think they're horrible, and they ruin my life. They're gone. They're going to challenge that person. If a person says, yes, I had medical treatment by a psychiatrist and I was on medication, that begs the question, how did that work out for you? Was there any issue with the medication? Anyone that has any issue whatsoever with mental disease, defect, or medications is going to be tossed because of alleged cause. They're going to say it's for cause because they have a preconceived notion. And that's going to wipe out a significant number of citizens that are being brought here to this court to sit on a jury, recognizing the fact that the issue of mental disease, defect, treatment, lack of criminal responsibility is central to this case. I certainly have no problem, and I have confidence, as we always say, that the court will give a very forceful instruction to the jurors that regardless of any preconceived notions, that they come into this court with a clean slate and they have to listen to the testimony and listen to the evidence. We do it all the time, usually to the detriment of the defense, but we do it and we say, okay, can you understand what I'm telling you, that you don't have to listen to this, or that you don't have to feel the defendant has to present their evidence, and we accept them as jurors. So I don't think it's fair to exclude a potentially significant number of people that would be good citizens, good jurors, just because they have had mental disease or treatment, psychiatrists, psychologists, MDMA, or whatever they call it, or any of those treatments, or medical issues with medications. I just think that we're flirting with disaster on that type of question.
So what would you want me to just ask
I-
number three?
Number three, looking at number three, I think is fine. The defense in this case is that Ms. Clancy is not guilty due to not being criminal or lack of criminal responsibility at the time she killed her 3 children. This is commonly referred to as an insanity defense. Is there anything about this so-called insanity defense that would offend you or cause you to not be able to fairly decide this case? And then they come up on the individual voir dire and they say to you, in our presence, yes, I don't like psychiatrists, or I don't like psychiatric medications, or my brother did something or other. Yeah, I think question 3 captures it. Instead of going through all of those questions, number 2, 4, 6, 9, I think number 3, I have no problem with.
Commonwealth?
Your Honor, I think the questions should remain as they are. Defense counsel's only objection to them seems to be his belief in knowing how we're going to make decisions and how we're going to address issues or answers that come up at sidebar. And he is wrong about our approach, and he is wrong about the way we handle things. I can speak for myself, and I can say that if a person comes up and says that they have had mental health treatment, mental health medication, I have no issue with that, as long as they can be fair and impartial to both sides. And I mean both sides, not just me, to the defense as well. Now, his example that he gave, that someone says, I had an awful experience with a doctor, it ruined my life, and I can't be fair and impartial. I should think that neither side would want to take that person, because we want a fair and impartial trial for both sides. So I think the questions are fair. I think the questions get to the heart of the issues that will be in this case. And I think a lot of them get to the issues that case law in this area addresses we should ask about. So I'd ask that you leave your questions as they are.
All right, I'm going to take a look at it. I don't think I'm going to go just with 3, but I may combine. There are a couple of kind of just going over the same kind of area. So I think if I can condense those, that's probably what I'll do. And I'll give parties the chance to be heard again in regards to that. So it'll probably be 3 and then maybe one other one addressing that kind of issue. All right, anything else?
Would you want to consider adding the question of, do you understand that a defendant does not have an obligation to present any evidence or testify? In the
I'm
case?
just so everybody knows, what I'm also going to do is after we have the questionnaire, I'm going to bring them up, bring each juror over to the side, and then I'm going to ask, some additional questions, including defendant not having to testify
Okay.
and understanding not having to present any evidence.
Yep, that's fine.
Questions about police credibility, all those type of things that I would generally ask. I was just having the questionnaire because these are kind of issues that those type of questions in the questionnaire may be easier for people to go and kind of reflect a little bit instead of just standing up here for the first time being hit with these type of questions in front of us. So I will ask, defendant does not have to testify. The defendant has no obligation to present any evidence. The police credibility question, kind of things along those lines, I'll ask over here. And then the parties can have, reasonable follow-up as well. All right?
Thank you.
All right, anything else?
Finally, you gestured to that side of the bench. Would the individual voir dire be?
The individual voir dire, that's just by force of habit.
Okay.
The individual
I was gonna
voir
say,
dire,
we
as we
need that.
discussed before, will be
Yep.
done over here.
Perfect.
Defendant will be here, sidebar.
Okay.
And then, and that's part of why we're going to take that break, to have the jury go back, fill out the questionnaire, then we'll set it up for the individual voir dire. We'll do that over here.
Good, thank you.
Okay? All right. Now anything else?
Not for me.
All right, come on. All right, well, thank you very much. We'll see everybody on Monday, 9:00. We'll begin the impanelment. As you know, it'll probably take a little while before we get the jury up here, but so if there's anything that we have to address before I go talk to the jury, we can do it then. All right?
Thank you.
Counsel, thank you.
Thank you.